This case starts like many others, with a defendant hoping for mercy. But within minutes, the courtroom takes a shocking turn no one saw coming. A mother of 3 walks in asking for deferred adjudication, basically a second chance to stay out of prison, continue working, and get treatment. But then the judge starts asking the hard questions, and the answers begin unraveling everything. What was supposed to be a simple sentencing hearing suddenly becomes a deep dive into addiction, accountability, and whether this defendant is telling the full truth. She admits she'll fail today's drug test. She confesses to using meth before court. Then the judge uncovers scales, baggies, and nearly 30 grams of meth tied to her case. Now the courtroom is faced with a brutal question. Is this a struggling addict who needs help, or someone minimizing serious criminal behavior to avoid prison? And just wait until the judge explains why she's not walking out of court today. This hearing turns from hopeful to devastating in seconds. Stay until the end, because the final ruling may surprise you, and it comes with one last warning that every defendant should hear.
I'm sorry. Thank you for, giving me an inpatient program.
Well, no. I'm not saying I'm going to give you
Oh, I'm
inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today. Sentencing today, according to the plea bargain agreement, she pled no contest to count 2 of the indictment. She applied for deferred adjudication. The state is proceeding only on count 2 according to the plea bargain agreement. Punishment is to be assessed at 6 years in the prison, and the state is silent on the defendant's application. The court requested that the defendant's criminal history be provided to the court. There were no objections to the court receiving that from the state. Is that correct?
Correct.
And any objections to the court reviewing that?
No, Judge, of course not.
Right. Thank you, state. All right, the state is silent. Is there anything you wish to say on behalf of your client?
Judge, of course, Ms. Torres is hoping you'll grant her application for deferred. She's self-employed, cleaning houses. She has several customers that rely on her. She has a few kids. She's just asking for the court to maybe direct her to some outpatient treatment because she believes she needs some help with this problem. And other than that, again, she's just hoping you'll grant her application.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your
All right, you can lower your hand, state your name for the record.
Honor. Missy Torres, Missy Ann Torres.
All right, so you're going to get drug tested today. What are the results going to be?
They will come back positive.
Positive for what?
Right here, the case takes a dramatic turn. Instead of denying everything or trying to hide it, she openly admits she uses meth when under stress. That honesty may help her credibility, but it also reveals how serious the addiction has become. Notice the contradiction too. She wants leniency from the court, yet she used drugs while waiting for sentencing. That's a major red flag in any courtroom. Judges often look at behavior leading up to sentencing as proof of whether someone is truly ready to change. If you can't stay clean before court, how likely are you to stay clean after? And let's be real, stress is something everyone experiences. The court now has to decide whether stress is an explanation or just another excuse. What do you think? Should honesty earn sympathy here, or does using before sentencing cancel that out completely?
Methadone.
All right, so how often are you using meth?
I only do it when I'm under stress, and I did it because I could get denied for adjudication, so
I'm sorry, what?
I could get denied the application, so I just kind of was I just do it when I'm under stress, so I know I have a problem, and I don't do it like around my children. I don't do it, every day. It's just when I'm under stress and I was really scared, and really under stress. So I don't do it when I go to work. I don't do it every day, like I said.
All right, so how many children do you have?
I have 3.
What are their ages?
11, 8, and 5.
And where are they now?
2 of them are with their dad, and 1 is with my grandma.
All right, with your grandmother, so their great grandmother?
Yes, ma'am.
All right. So, do you help take care of your children?
Yes.
How
I-
often?
I see them every other weekend, and I don't pay child support, but I pay them my exes and I have my daughter. My daughter is with me.
No, you just said your daughter is with the
Yeah,
great
but
grandmother.
I live with my grandmother. This was it.
All right.
So I help take care of she
All right.
helps me take care of her.
Okay. So one, I don't think it's appropriate for you to be cleaning houses
Okay.
because of the nature of this offense. And two, I don't think it's appropriate for you right now to be taking care of your children.
That's why I'm asking for help now.
I'm sorry, what?
That's why I was asking.
This is the moment reality hits hard. The judge makes it clear that outpatient treatment is off the table and that custody starts today. That means no walking free, no going home, no delayed consequences. Why? Because courts weigh public safety and personal responsibility heavily. She admitted active meth use, has children depending on her, and the judge clearly believes she is not stable enough right now to remain unsupervised. The most powerful part here is when the judge questions whether she should even be caring for her children at this stage. That's not just punishment, that's concern about fitness, judgment, and environment. This is where many viewers split. Some will say the judge is being too harsh, others will say this is exactly the intervention needed before things get worse. Let us know, which side are you on?
For help, Your Honor. That's why
All right, your help is not going to be outpatient treatment if I grant this application for deferred adjudication. So you're going into custody today.
Okay.
All right. So it's just a matter of what I'm going to do with you. I will tell you the court's issue, and if you want to address this, I know the state is proceeding on count 2 of possession, but she had a lot of drugs with her.
No.
So I don't understand, if you're working homes, then why do you have a scale with
Wait.
you? Because that's, according to this, you had drugs, you had a scale in your purse, and there were baggies totaling 32.0 grams.
Well, Your Honor, I was a heavy user back then, and it was.
Oh, you're not, I tell you what, I don't think, and if I'm wrong, correct me. I don't think you were using 32 grams of meth.
It was only 28.
No, you have meth here for 4.964 grams, and you also have meth for 27.459 grams. And what you pled to in count 2 was a possession 4 to 200 grams. So this is not a possession 1 to 4. So we're talking about 27 grams. And according to the stipulations, that what was found in your bag, it says, I searched her bag and inside a Paris Hilton makeup bag box were baggies, a scale, and crystal-like substance inside a cut vacuum sealed bag. That's from your Paris Hilton makeup bag.
So what I had, the meth was it was double bagged in a sandwich bag. So yes, ma'am, I know it was 20, but it's because that was my personal. I didn't have any other. And last time I went, they tried to only give me which was 14 grams. So I had to.
No, what I'm telling you is, they said the baggie found in Robert's pocket tested positive for meth and had a field weight of 6.12 grams.
That wasn't mine.
No. I'm not saying that was yours. So the 6.12 grams that were found in his pocket, they're saying that was his. It was in his pocket. But the baggie, which was found in Missy's purse, tested positive for meth and had a field weight of 32.09 grams. Now, mind you, what they do in the field, I already know that testing drugs in the field are not legal for court. So I'm not considering the weight and what they said in the field. I'm considering what has been given to me for laboratory reports. So this was the professionals testing it.
Now the evidence becomes the star witness. The judge breaks down the actual lab-tested drug weight, not just field estimates, and that matters legally. Lab reports carry far more credibility in court than roadside assumptions. And look at what's bothering the judge. Not just the meth itself, but the scale, baggies, and packaging. Those items can suggest distribution, even if the charge being handled here is possession. That's why the judge keeps pressing her story. Her defense is that she was a heavy user buying in bulk for personal use. Believe it or not, that does happen in addiction cases. But it's also a claim courts hear often. This is where credibility decides everything. Is she being brutally honest or strategically honest? Because once a judge stops believing your explanation, sentencing usually gets much tougher.
Not a presumptive, and it says 27.459 grams was the net weight of the meth that you had in your Paris Hilton bag.
Yes, Your Honor. And I will say that I used to use a whole ounce within 2 to 3 days. So I was a heavy user, and like I said, they tried to give me half of that the last time, and right now it's going for 250. So if I'm paying 250, I wanted the whole thing. I wanted to make sure. I'm just being honest, and I'm sorry. Excuse me for being.
No, I
Transparent.
want you to be honest and I want you to be transparent.
I'm sorry for being transparent, but it's something that I feel like I worked for my money, and I didn't want just to get gypped again. I can promise you I didn't sell anything. It was because I've been gypped many times. So I did get it. Now it was double bagged because I don't know, that's the way they gave it to me. I can't, and it is my mistake, and I'm taking full responsibility, but I wasn't selling drugs. I wouldn't. I guess I have a job, and back then I was, a heavy user where I would just do it before work, after work, and I didn't have my children in my life. Now I do have my children back in my life, and I'm trying to be a good mom. So I thank you for, giving me an inpatient program.
Well, no, I'm not saying I'm going to give you
I'm
inpatient.
sorry.
What I'm saying is that you're not walking out of this courtroom today. Either you're going to be going to prison or either you're going to be going to inpatient treatment. So it's very important that you be 100% honest with me, because I'm telling you, the state proceeded on a possession, but the amount of drugs you had and the way they were packaged, that's concerning for the court. So you're saying that you just bought a bunch of meth and you were saving it up for use?
So I would use within 2 to 3 days, that was all my personal. Like I said, they tried to sell me half of that one time, and I went back to the same person, but I said, I'm gonna weigh it myself to make sure I'm getting the right amount, because it's just, I'm an addict. I'm sorry, I am. And we're not.
So you travel with your own scale?
Well, at the time I did, because like I said, I've been gypped, and when you're an addict, that's all you think of, just how to get, make sure you're getting what you need. And honestly, I can see where I made my mistake, but I'm being honest with you. It was my skeleton measure. So my personal, that's it. And I don't know if Robert would tell you that was my personal as well. Like, I mean, I don't want to call him or anything you can if you want to, but he would tell you that's what I used to pick
Oh, no, I'm not going to be calling Robert, because Robert probably has a case of his own.
Right. But I'm saying Robert can tell you too, within 3 days, maybe 2 to 3 days, really, it would have been gone, and I would have been back doing it again. Now I don't. It was kind of like a stress thing.
This may be the most damaging admission of the entire hearing. The judge asks where she got the drugs she used today before court, and she admits she got them from an old friend just days earlier. Think about that. She was about to be sentenced for meth possession, and still chose to use meth right before appearing in front of the judge. That signals a severe addiction problem and almost no impulse control. Even the defense attorney recognizes it, shifting strategy from asking for leniency to arguing she needs treatment immediately. Smart move, because at this point, pretending this is a minor issue would destroy credibility. Sometimes the strongest defense is no longer innocence, it's acknowledging the depth of the problem. But has that realization come too late?
And
Where did you get your drugs to use today before you came to court?
Just an old friend. I hadn't talked to him since, and it was on Saturday when I knew it was, coming, and I guess I felt, under pressure.
Good. If
Yes.
I say something, I think the fact that she would actually go out and do the same drugs that she's about to get sentenced for in a couple of days, I think really speaks to the fact that she has a serious addiction problem that I think only rehab can treat. And if you decide that's ISF or SATF or SAFE, we understand that, but I think she really needs treatment.
Okay. All right, this is what the court is there anything else for me to say? All right, this is what the court is going to do. I see that she hasn't been to prison before. I'm going to find her guilty, sentence her to 6 years in the prison, the therapeutic community. There's to be no contact with Robert Marble, give her credit for any time served, and I'll retain jurisdiction.
Okay,
And you can explain to her what that means. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I'll tell them. So here's the thing. When I say that I'm going to retain jurisdiction, what that means is they're going to take you to prison. If you're following the rules at the prison, if you're working on yourself, because they have programs at the prison, your attorney can file a motion. It's called shock probation. Back when I was growing up, they would have scared straight programs. So shock probation is sort of a scared straight program. So hopefully when you go to prison, you will clear your mind.
Yes.
The drug use or the addiction that you have, the craving that you have will be lifted. And if you are doing
so,
what you're supposed to do at the prison, if there are no bad reports at the prison, when your attorney comes back for a request for shock probation, I will strongly consider it. So while you're at the prison, you have 180 days. That's when he needs to bring it back before me before that time period. So you're going to do 6 months. And if you are doing well, if there are no write-ups against you, then the court will strongly consider giving you probation. You understand?
Yes, ma'am.
So, well, I mean, these are going to be choices that you make. It's going to be completely up to you whether or not I strongly consider giving you probation. Your attorney will explain it to you further, but any programs that they have at the prison, like the therapeutic community, to address your issue, you need to take it. I know they have parenting classes at the jail. I don't know how long the transfer will be, but you need to take advantage of that. When you see people come before me and they've gone to anger management class, they've done parenting classes, they've availed themselves of everything at the jail and everything at the prison, that is what you need to do. You need to immediately sign up for it. If for some reason there's overcrowding and they don't give it to you, it would be better for you to have signed up for it than to just throw up your hands and say, I'm not trying. Do you understand?
Yes.
And next time, if you have a case before any judge, don't use before coming to court. You understand? But I do appreciate your honesty, but you're going to have to get your life in order. Otherwise, children is going to be without their mom. You understand?
In the end, the judge sentences her to 6 years, but with an important path forward: therapeutic community treatment inside prison, and the possibility of shock probation after roughly 180 days if she follows rules, avoids write-ups, and commits to rehabilitation. That means this wasn't just punishment, it was structured accountability. The court recognized addiction, but also refused to ignore repeated bad choices, especially using drugs right before sentencing and minimizing the seriousness of the case. The judge's final message was powerful. Your future now depends on the decisions you make next. For many defendants, that's the real turning point. This case shows how courts often balance compassion with consequences. Help is available, but honesty without action is never enough. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
All right. Good luck to you. You're welcome.